Guess what time it is? It's time for eviction hour. I feel like we need a theme song. Like tonight, I feel like it should be the Rocky theme song. I don't know why. I just feel like we should have a theme song for this. So put it in the comments what you think our theme song should be for eviction hour. We're excited to jump into this. We're going to talk a little bit. You know what? We have so much darn stuff to talk about. I don't know if we're going to get to everything tonight. I wanted to talk about best practices for landlords. Hopefully, we'll get a chance to chat about that. There's a huge update on 3-day notices based on a trial that just happened in end of June. So that's a big update we have to do. But without further ado, speaking of do, let's bring in. I was early on my applause. There we go. Zachary Miller. Zachary Miller. So, look, we love having the whole team here, and it would be amazing if we could, but they couldn't all join us because you guys have at least 4 jury trials, you were telling me. And you're dividing and conquering, but there's not enough for you to go around. So tell me what happened with the 4 jury trials. Just a quick overview, Zach.
Yeah, so I mean, we're getting sent out left and right. More and more tenant attorneys are demanding jury trials and announcing ready, and that's only going to continue to increase. LA recently passed right to counsel. Unincorporated LA County already had a right to counsel. So the volume of litigation, the number of attorneys that are going to be engaged in trial is only going to go up. So we're really at the tip of the spear and getting the brunt of it. But so far, so good. And so, yeah, happy to, steer our clients through. For most of them, it's their first jury trial. But for us, it's just another day in the office. So
that's it. Or technically out of the office in
out of the
front of
office.
a jury. So, no, we're super excited to have you here. I shouldn't say it, but you're one of my favorites, Zach, and the team. But I probably would say that same thing if it was any one of you here. But so it's like your kids. Like I got 4 kids, and they're all my favorites, and that's how I feel about California Property Law Group. Not that you're my kids, but that you're each of my favorites. So remember, the guy in the tie is the one who's the attorney. He's the one who can give legal advice. I can't. I'm just a real estate broker who happens to love to talk about landlord tenant law and a whole lot of other stuff. When Dingo Productions is saying there's nobody in the chat, don't you worry. They're going to show up and we're going to start being pelted with questions. In fact, I'm feeling ambitious tonight and I'm going to potentially try to do something I've never done, and that's actually to bring on a live caller. I've got the technology sitting here if the technology will cooperate. So let us know in the chat if you want to be a live caller. You don't identify yourself. You're going to use your YouTube handle, and you can't use names or anything like that, but it could get ugly. We'll see what happens. And don't forget, Michelle's in the background taking care of things. So first things first, Zach. Shein versus Sepeda. Tell us all about that. June 25th, 2025, I believe, or June 26th, 2025. What happened?
Yeah. So this year, basically, there's a court case which almost the entirety of the opinion has nothing to do with what the fuss is about. There's one paragraph in that opinion that is sending shockwaves through the property ownership, property management community, and it suggests that if you serve a notice and the notice doesn't say either when the notice was served or when the notice expires or both, that the notice is invalid. So you can see what that would already do to thousands of evictions that are in progress with thousands of evictions to come. Changing it's not like there's a change in any statute anywhere. It's not like this is going to be written on a big billboard. It's literally one paragraph in a 20-something page long case that's totally changed what landlords have to do to evict their tenants. It's made the process a little bit more difficult. And so everybody's kind of scrambling to adjust. The AOA recently came out with a new notice, new 3-day notice that has the date for service that you have to fill in, right? Or at least, be accurate as to when it was served. A lot of times what happens is that you hire a process server or the sheriff and you give them the notice to serve. You don't know what day they're actually going to serve it. So now this is bound to make it harder, give tenants even more instant wins, due to what I think was frankly an unnecessary decision. There were a number of other reasons why they could have ruled the way that they did, and they chose to, for reasons that are unknown to me, to sort of digress and focus on something that had never been a really part of California law, and say, for the first time ever, you have to put either the date that the notice was served or the date that the notice expired. So big, I mean, yeah, it's going to affect a lot of people. Unfortunately, it puts another trap for the unwary, which unlawful detainer evictions already have millions of traps for landlords. This is just yet one more, but something that, yeah, people should be aware of.
And they're not little traps, they're bear traps that grab on and destroy your entire case. Literally, I'm not exaggerating. And so just to flesh it out, when delivering a 3-day notice, before this ruling, you basically show up, knock on the door, attempted to deliver to the person that was there, or substituted service, somebody else who's 18. And it was 3 days after that, for example, if it's 3-day pay or quit, it would be 3 days after that that the money would be due. If you don't pay it by those 3 days, then you can move forward with the unlawful detainer. So what the law is saying is you have to be specific, like Zach said, when it's served, or when the 3 days ends, or to be even more specific, how about both of them, when it's served and when the 3 days end? So it's a big change. And look, that's why you hire the professionals, and the law literally changes weekly now. We're seeing it. That's why you hire professionals like California Property Law Group to make sure that when a notice is served, it's served correctly. So in this vein, anybody, I mean, who's kind of maybe down the road on an unlawful detainer action based on a 3-day notice, should they start over with a 3-day notice? What are your thoughts on that?
I'm not recommending that people do that yet. I think that there's enough, how do I put this? There are a number of ways that you can address this. If the tenant admits receipt of the notice and admits that they knew when the notice period started, maybe you can get around it that way. Depending on the exact wording on your notice, some notices might fare better than others. But it will become an issue, which is why everyone is changing their processes now to try and get ahead of the issue going forward. But I wouldn't recommend, for someone who's got an unlawful detainer action already in progress, I don't think it's worth it to throw your hands up and say, we're going to lose for certain. I think that every case is going to be different. And I do think that there will be ways to try to save cases that are currently ongoing. But going forward, it's better to do the simple thing, show that you complied. It's just one more thing that you have to do. But yeah, I don't think that everybody is
No.
on it right now.
And you're very conservative in your answers because of your deep understanding of the law. And I mean that as a compliment. So if you're saying that you don't need to start over, then I'd feel pretty confident about that. Now, question for you, and you may not know on this particular case, but I know that judges are stepping in from, for example, like traffic court judges are stepping in to help with unlawful detainers. I heard that. Is that true?
So yeah, so if you are doing, let's say, a jury trial,
Yeah.
they've opened up. All sorts of judges will hear unlawful detainers, and most of the time you don't have the, let's say, routine unlawful detainer judges doing jury trials. They've started to do jury trials to try and help accommodate the massive number of jury trials that go forward. But if you're doing a jury trial, you might be assigned to someone who ordinarily handles regular civil cases, traffic citations, and things that are totally dissimilar to unlawful detainers. So sometimes this might be the first unlawful detainer case a judge has really ever dealt with before. So adding to the complexity, you have an incredibly arcane a set of rules that are scattered throughout, half a dozen different places, county rules, state rules, local municipality rules, federal rules, common law, contract principles, state appellate court decisions, regulatory agencies. All of that could be in play for let's say a judge who's never dealt with any of that before. So yeah, depending on now, everybody will have a 170.6. So if you happen to draw a judge that you don't like, you can exercise a peremptory challenge one time. So you can say, I don't want that judge. But yeah, I mean, I'm not going to speak ill of the judges in
Mm-mm.
Allen County. I think they do a great job.
Yeah.
But yeah, it's a lot to ask of anyone. Even the most highly specialized experts in this field really struggle to
Yeah. No, and this is definitely not at all to an insult to the judges. We appreciate all of their hard work and what they're doing, and we appreciate them stepping in to help with these jury trials. I just maybe was wondering if there's a chance in Shein versus Sepeda that it maybe wasn't a judge that normally dealt with unlawful detainer.
Well, so
And
this is the appellate. So hold on a sec. So this
oh, interesting. Okay, okay, go
so
for it.
lower court cases have no precedential value. So if you win a
Okay.
trial, okay, good for you. That resolves the issues between the parties. My understanding of Ashagian was that it went up to limited civil unlawful detainers. So unlawful detainers, they're asking for less than $35,000. Go to the appellate division of the Superior Court. And this went to the appellate division of the Superior Court, who are considering some issues that are unrelated to why everybody's like sort of freaking out. And the appellate court took it from them and made a ruling on it. So the appellate court is above the appellate division, or rather, I should say, the appellate court handles cases that are unlimited and can take cases from the appellate division. And so they're the ones who came out with this. And it's true that the appellate division and appellate courts of California typically author, 4 to 8, maybe unlawful detainer published decisions per year. Yeah, and so when they do, it always changes things. And so this is really one of the biggest ones of 2025. It's going to change every single non-payment of rent notice in the state of California. And it's really going to, yeah, I think, have a big effect. But currently, we're really at the tip of the iceberg, right? So yeah, it just came out, got published on the 26th. So it's taking time to sort of filter through.
I love it. I love like watching you think and explain through all this stuff. You know your stuff so well. This is fun to me. So the appellate court, that again, why you need an expert like you guys to be tracking what the appellate court is doing, and then at the same time in the lower court, if you happen to have a judge that doesn't do unlawful detainers all the time, having somebody to represent you to make sure that the process is done correctly, because I'm assuming on some level they're going to lean on attorneys in certain cases, or certain, I shouldn't say cases, certain examples, they may lean on you guys in the courtroom if it isn't something they do every day. So is that true?
Yeah, very much so. And now more than ever, I think that, I mean, so moving forward, millions of tenants in the city of Los Angeles are going to qualify for free legal representation. So you're at even more of a mismatch or a disadvantage if the landlord is self-represented and the tenant has a government-provided attorney, and you're going in front of a judge who maybe isn't, let's say, as experienced with unlawful detainer. And so you, as a let's say a landlord, a self-represented litigant, would not only have to very quickly learn all the rules of civil procedure and the rules of evidence and courtroom specific rules, how the judge likes, you would also have to learn all the substantive unlawful detainer. It's just too much, I think, for most people, which is sad to me. As a lawyer, I make money off of it, but as a person who lives in America, it is sad to me. I like, for example, you're informed about the law and use your knowledge about the law to make informed decisions. That makes me happy to be a citizen in a free country where the law is the common property of all mankind. It's not just something for guys in ties to monetize.
Yeah, there you go. That even rhymes.
But unfortunately, in California, I mean, really, yeah, what you don't know can hurt you. So having competent legal counsel is a must. But of course, I would say that.
Thank you for that. Yeah, and that's it. It's like doing your taxes. Like there was a time and place where it was easy to do, but now you need a pro for that too. So let's bring in one of our first questions here, Jessica. Jessica's seeking an attorney that can help negotiate a rental credit that the landlord agreed to provide and is now trying to reduce. Any attorney recommendations? So this is an interesting case. It sounds like there was going to be a credit maybe prior to move in, or could have been while she was there, but that credit is now being changed. This, I mean, if you wanted to kind of ramp it up with the landlord, I would say just withhold that amount that is in dispute, and then the landlord's going to. I mean, then you essentially the landlord's going to have to get an eviction attorney involved.
Yeah, I
What are
think
your
that
thoughts on this, Zach?
this unfortunately highlights, let's say, a problem in American law, which is that you have this big access gap. Most of the attorneys, any of the attorneys that I say would interact with, would pretty rapidly, their charges would pretty rapidly exceed the amount of, let's say, the rent credit, for most people, most of the time. So you have a couple different avenues. You have some free legal services, like the Legal Aid Foundation of Los Angeles, the Eviction Defense Network, public counsel, etc. They will have attorneys and clinics who can assist you at no cost or low cost. Then also you have small claims. So basically, if things don't work out, small claims is a very efficient forum for resolving disputes that are worth less than $12,500. Maybe this rent credit is huge. You know what I'm saying? Maybe this is a multi-million dollar rent credit or something that could happen. You know what I'm saying?
Yeah,
Yeah.
yeah,
Yeah.
yeah.
But assuming that this is, let's say, less than $12,500, that's an issue. Small claims is a very efficient forum for resolving disputes. The nightmare scenarios where you have an amount of money that's due that's greater than 12,500, but is not yet in the hundreds or millions of dollars, or hundreds of thousands or millions of dollars, because in that place it's tricky to make it
Yeah.
math out to make it affordable for an attorney. But I think that for the bulk of people who are looking for sort of advice in your situation, I'd recommend legal aid, EDN, public counsel, VetZedek, and small claims.
Yeah, that's a great advice. The small claims. So with small claims, they actually just increased the limits, so they took it up a little bit, which is helpful. And then neither side can have attorneys there, which is good in
Yeah.
some respects. It
Yeah, no, I
speeds
know.
things
Look,
up both
I'm
ends.
very familiar with the Shakespeare quote about lawyers, and yeah, there you go. So, yeah.
No, that's great advice. All right, so we're going to continue to run through things. Put your questions in the chat, and we will answer them as we go. So one of the changes this year is that when an unlawful detainer notice is or paperwork, the notice is dropped off, the renter has, instead of 5 court days to answer, which is what it was before, they now have 10 court days to answer. And by court days, we mean not weekends and not holidays. How has that changed the
Yeah,
process, in your
so
opinion?
that has slowed certain parts of the process down. It means that where you have multiple people on a rental agreement, things are taking way longer, because what'll happen is that somebody will answer, and so ordinarily when somebody answers, you want to request a trial. If you only had one defendant, somebody answers, okay, let's request a trial. And maybe you do discovery, okay, fine. But an unlawful detainer, you're trying to go fast, you'd like to request a trial. If you have two tenants, somebody answers and somebody doesn't answer, you have to wait for the default period to expire before you can move forward and request for trial. What that means is that for people who have two or more adults living at their rental properties, in the event that not everybody answers, the process is significantly slower, because you first have to
Mhm.
default out any non-answering parties, and then you can request for trial. And in the unlikely but let's say unfortunately common occurrence that the clerk rejects a default or doesn't like the proof of service given to you by a process server, the time to fix those kinds of mistakes is even longer, right? So as before, if you served somebody and there was some issue with the service attempt, you would find out in 5 court days or a little bit more. Now you're waiting for those 10 court days, and where you have courts that have significant backlogs, you could be looking at a month worth of delay, whereas before it would be shorter than that. So the change is having, I think, the intended. I think the change is also allowing more people to respond. So I think you are seeing a higher percentage of cases where people are answering. But in cases where people don't answer, it's making the cases take much longer.
That's fascinating. I wouldn't have even guessed that, because it seems like it's giving more time for those who do answer. But no,
Yeah,
you're
so
right.
it's yeah
It's the other
for
ones.
the people who do answer, normally they answer pretty quickly, or it's not that common to have somebody answer at the very end of the process. So what ends up happening is that you end up just waiting longer for somebody who, in some scenarios, like might not live there anymore, might whatever, be dead, might be who knows, yeah.
Yeah. That's funny. So, like you were about to say, like the intent was to theoretically give folks more time to answer, but you're right. If most people are answering quickly anyway, and the rest are just
It just
ignoring
makes
it, it's
it
just
just kind
dead
of
time.
wastes
That's
time for people that were never going to answer anyway. With that being said, I mean, I'm sure that answer, you know, uh, the percentage of people that answer, I can imagine, has gone up, but that's also could be due to a number of other factors. On net, I wouldn't say this was the greatest change in the world. It did come with some welcome fixes to things like demurs or motions to strike that sped them up to try and remove some of the more common gamesmanship tactics that tenants would employ. But on net, I don't really know that this is, yeah.
And by gamesmanship, you mean that the tenants were employing. It's basically just they know that they need to be out, but they're because they they aren't right, but they're
Yeah, so
playing games to
sort
drag
of
it out.
the saying is the process is the punishment. You can file things where you know that you have no hope for prevailing, but you're putting the other party through the expense and the delay of needing to resolve those things. So
Yeah.
for people with billions of dollars, it's not a great strategy because you can ask for sanctions and so on. But for people who have, what's the Janis Joplin quote or whatever, nothing's just, or yeah, freedom's just another word for nothing left to lose or something like that. These people have nothing left to lose. So
I'm impressed. Your quotes are good. Oh, Jessica has a follow up. So the landlord is the Irvine Company in Orange County. So that's take them to small claims. They'll hate that. It'll be a pain in the butt for them to do that, Jessica, because they won't be able to send one of their high paid attorneys to go. So, all right, a few more questions here. Frank, tenants are suing me for harassment. Cops came 4 to 5 times recently. One tenant got a DV misdemeanor and the door was busted. Can they use these incidents in their lawsuit? We might need some clarification. Is it which tenants are suing for harassment? Is it the ones that the cops were called on, or did you call the cops, Frank? Maybe do you need some more
So I mean, I
clarification
can
there,
speak
Zach?
sort of generally. That How do I put this? Landlords can, in certain circumstances, be required to take action to prevent, let's say, one set of tenants from bothering or harassing another set of tenants. So that might be what's going on here. So, in the event that this is a good reason why it's good to have in leases and so on prohibitions against, illegal activity, against harassing other people. And if you become aware of illegal activity or tenants that are harassing other tenants, that tell them to stop, warn them, and then if they don't stop, then potentially evict them or otherwise take action to prevent them from doing that, because you can sometimes have liability for failing to appropriately respond if there's a tenant who's bothering another person. Here, I mean, yeah, so we're also looping in domestic violence, which in California also has its own sort of rules and complications. I'm not going to get into that off of this because it's sort of far afield. But suffice it to say, if you're harassing them, don't. Okay, bad idea. Good way to get sued. Um, and then additionally, if you know that there's somebody in the building who's harassing the tenants, you really need to take steps to prevent them from harassing the other tenants. And you can talk with an attorney about kind of what those steps could be.
That's good advice. In
Yeah.
general, don't harass your tenants. Yeah, it's just call
Harass us.
Zach
Yeah.
and Kenny and Raphael. Yeah, if they can harass your tenants legally, they will, and I mean legally. And I'm only joking. It's not harassment if it's legal. So, all right, we got a good question here from Sam. Sam says, "I have a duplex under statewide rent control only, so it's under the Tenant Protection Act. No local rent control. Both units are identical. I want to do owner move in. Does it matter which unit I want to move into?"
I'm saying no.
What do you say, Zach?
My understanding, so in this, yeah, it's under statewide rent control only. In certain
Yeah.
jurisdictions, like local jurisdictions, you'd have the requirement to evict the newest tenant. Here, yeah,
Hmm.
yeah, it doesn't matter. With that being said, the law will allow you to have no reason at all, but you can't have a prohibited reason. So if you said, well, the guy in Unit B is a military veteran and I hate veterans, so I'm going to evict him because he was in the army, or he's Portuguese and I despise the Portuguese, I'm going to kick him out because he's Portuguese. That's a bad reason. You'll lose the case. So don't do that. But other than that, yeah.
That's good advice. No, that's good advice. So, and then just to add into that, SB 567 changed owner move-in under the Tenant Protection Act. So there's going to be required statutory language. Actually, yeah. So the required statutory language, you basically need to have in the rental agreement that this is an allowable, no fault reason to terminate tenancy. And the other important thing is you're going to actually have to tell the renter who's moving in and what their relationship is to the owner. And the tenant can actually request proof of that. So that's all under the Tenant Protection Act. So, okay, let's see. More questions coming in. This is what I like. Okay, so Frank clarified it was the manager whose door was busted down by the police because of the domestic violence against his girlfriend. The whole building is shaken by the event, and I'm worried the tenants will add these in their lawsuit. That's an interesting twist on this.
Yeah,
as
so
the
now we're getting,
manager.
how do I put this? I suppose that now we're getting into kind of more evidence than we are. So it's not clear to me that this would provide a cause of action to the tenants that they didn't already have. So if, let's say, my neighbor has their door kicked in and I'm shaken up, I don't really have a lawsuit against that person, even though, maybe I didn't enjoy seeing it. Okay, whatever. If you want to use this to prove that, hey, this guy harassed me, and you know how I know it, he harasses other people, that is an incredibly sensitive area in evidence, right? So there's, yeah, generally a prohibition against using someone's prior bad acts to show that they acted in conformity with that, let's say pattern. Yeah, it's very sensitive. So yeah, you've sort of unwittingly stumbled into a kind of interesting area in evidence law. But
So to summarize what you just said, like just because you were bad in the past does not automatically make
yes,
you bad
except
right
for
now,
certain kinds of
right?
cases and certain kinds of, they have, like, for example, to show motive, to show like a signature kind of style of how you, yeah, serial killer,
Like a
like,
serial killer.
or
Well,
for other unhappy subjects, we'll leave it there. But for other unhappy subjects, there are
yeah.
exceptions to this. But I wouldn't say, I would say, don't worry about that so much. This sort of doesn't, yeah.
Now, how about this though? How about the fact that it's the manager for the landlord? Does that bring an extra layer, not necessarily of harassment, but should the landlord, and this may fall outside of the particular law that you're an expert in, this might be like HR law, but should the owner get rid of the property
Well, so
manager
I
in this
mean, yeah, if
case?
you so a couple things. So we're kind of talking about vicarious liability a little bit, right? Which you have the manager. Typically, they're going to be held, the employer is going to be held responsible for the actions of their agents when they're acting within the scope of their employment. So here it's a manager interacting with tenants. You can be on the hook. Now, if the manager, let's say, went out and got a gun and wanted to impress Jodie Foster and shot the president or something, you're not going to be held responsible for that. But but if the manager is kicking in people's doors and trying to get the rent money, now we're starting to see that this is related to what they do for a living. So that's the doctrine of respondeat superior, which everybody learns about in law school. Yeah, so the fact that it's a manager is not good for you. It's going to depend a little bit on the facts of the case, but just know generally that if you have somebody who's like a building manager and they're acting within the scope of their employment, you can be held liable for the things that they do. And if you know that somebody, let's say, has harassed people in the past, it would be a good idea to either try and address that issue, right? Make sure, move them away from in-person interactions with the tenants, take appropriate measures to try and prevent this from happening in the future, or, think about firing the person and finding a different person if you think that it's really something where they're unsuitable for the role. But yeah, if you know that somebody has done things like this in the past, that they're kicking in doors, harassing tenants, where's the money? And, yeah, that you would want to take action to prevent that from happening again, up to and perhaps including firing them.
So you're not allowed to, in California, you're not allowed to kick down the door to get the rent money? Is that a law?
Custom, really. It's just kind of a gentleman sort of thing.
Yeah, point to the civil code. I want to see where it says you're not allowed to kick in doors. But no, there's other important stuff packed into what you said there. Number one is an agent. So a property manager acts as an agent. A real estate agent acts as an agent. So you can get in trouble when there's an agency relationship, like a real estate agent, like me. If we do something wrong, the principal can get in trouble for our actions. That's agency. And then two, having a property manager, on-site manager, and they do something wrong, just like Zach said, that can get you in trouble. So that's why you have to be careful. Don't think that hiring a property manager somehow is a layer necessarily of protection. It could actually get you into more trouble. And that's why landlords need to know the law, as well as, and in many cases, I hate to say it, better than the property managers, because they're not necessarily keeping up.
Yeah, I do. I mean,
do you agree, Zach?
Yeah, there are many people who would prefer to, not have to concern themselves with what's going on. But unless, these people have really deep pockets, unless Jeff Bezos is your property manager, you're still going to have liability. So you might want to make sure that you are, adequately supervising the people who are under your employ. And to the extent that you become aware of them having any issues or doing anything wrong, try to address it.
All right, so we're going to zag for a minute. I did this with Kenny. I'm going to bring you in on this. So we ran through some best practices for landlords. And with Kenny, we did 1 through 4. We're going to jump ahead. And we're going to talk about a few of these odds and ends. We won't take too much time, but I think it's helpful to get your perspective. So these are keys to success for a landlord to run a successful business and stay out of trouble as much as possible. So screening tenants thoroughly. You have to have objective screening standards, got to follow the local, state, and federal laws. Any horror stories that you can think of, Zach, related to improper screening?
Well, what'll happen quite frequently, and you'll see waves of it going through the community, is you do have attorneys who will find, let's say, a Section 8 recipient who will tell them, okay, we're going to have you sit down in a room and just dial landlords and say, do you take Section 8? Yes. Okay, thanks. Bye. Do you take Section 8? No. Okay, right? Gotcha. So yeah, the horror story is that, you answer a question which you think is innocuous, and it turns out to be a lawsuit. So yeah, screening appropriately. I will also say there are horror stories. So that's sort of, let's say, the landlord's not understanding the law. I've seen people who will rent out to someone that they think is one person that'll actually be a false identity. They'll rent out to someone they'll never move in and it'll be another person. I've actually evicted the same group of people twice who were doing that. Yeah, it's scam. Which is
this is exactly why I run through these steps with you and the team there, because we get
yeah.
amazing stories like this. We where the same renter had been evicted by the same attorney a couple times. That happened to another attorney I knew, and the attorney tried to use as an example that she lied on her application because she claimed she had never been evicted, and the judge wasn't sure because that previous case had been sealed. So the judge wasn't sure whether or not actually it was a lie because it was sealed. But anyway, I won't go down the rabbit hole on that one. And then the Section 8 story you just told, I talked to a property owner. She just inherited a property from her mom. She decides, yeah, I'll rent it out. She didn't even really want to. And she gets a text message saying she won't, saying, do you take Section 8? She, like you said, innocuously says, no, I don't. And ends up days later getting a letter in the mail. And there's, I think, like she said, like 25 25 lawsuits that this attorney's doing right now, and she can't get out of it. She has to settle for some ungodly sum. So anyway,
Yeah, no, yeah, those they kind of just rip through the community, almost like a cholera outbreak or something like that. They'll load up a bunch of these, and yeah,
that's the perfect analogy. So next piece of advice is to use solid legal lease agreements. Please don't just Google them up. Like my son Liam says, do not Google up your leases. You've got to make sure that they work locally, because there may be specific requirements locally, specific disclosures. And then share with us about the clause related to attorney's fees, if you don't mind, Zach.
yeah. So for attorney fees, the trick is that you want to cap attorney fees. So
Why? That doesn't seem to make sense. And we're talking specifically, like the lease will say, if one party goes after the other one, we're going to pay X for the if we lose for the other side's attorney. But if I win, I want to get $10,000 to pay my attorney. So why should I cap that?
right. So the reason is that litigation is always uncertain, and typically the kinds of cases that landlords bring are non-payment of rent cases, which means that if you get the tenant to pay your attorney fees, really you're just going to be adding on to an already uncollectible judgment. So you're going to get a piece of paper that says the tenant owes you, $100,000. You can add as many zeros as you want. The guy doesn't have money in his bank account. He can't even get Postmates. So how is he going to give you, a million, a billion, $1 trillion? Conversely, most landlords are collectible, which means that in the event the tenant wins, their attorney has the incentive to bill through to the moon. And I've seen attorneys bill tens of thousands of dollars just for the commute time, just for the time it took them to drive to and from the courthouse. Okay. I've seen attorneys bill for more than 24 hours in a day. I've seen attorneys, yeah,
That's
right.
attorney time. They have more than 24 hours in a day.
Oh man, you're slamming those Red Bulls. We've all been there, and time slows down, and you're just going a nice, stiff 25-hour day. Don't let them do this to you. You want to, so why would you want to have attorney fees that are capped? When, let's say you win, if the judgment includes any amount of attorney fees, then the collection efforts can also recover attorney fees, and then is uncapped. That's my understanding. So that's why you want to have a capped attorney fee. So in the event you lose, you're not being taken for tens of thousands of dollars for a defense attorney to drive around. But in the event that you win, you'll still be able to collect more attorney fees with the collections effort. So
That's great advice. No, and I appreciate that. And furthermore, there are attorneys, based on our discussions, and we've talked about this before, where the first thing they'll ask, like a renter will call up saying, my landlord's doing this to me. First thing they'll do is they'll ask for a copy of the lease and look for the attorney's fees clause, correct?
yeah, that's true. And so it really does, you can understand why from a public policy perspective, there are statutes that will give prevailing tenant's attorney fees. Like in West Hollywood, any tenant who wins automatically gets attorney fees, no matter what it says in your lease. But if you're the landlord and you're preparing a lease, don't do that to yourself. Give
Cap it.
yourself a chance. So I would take out, put in a capped attorney fee clause. So it would say something like the prevailing party in a lawsuit shall recover reasonable attorney fees not to exceed $500, $1,000.
Yeah. So 500 probably a good number to go with for that. Okay, so next important thing, stay on top of maintenance and tenant issues, address habitability, stay alert to tenant complaints. We talked about that, harassment and things like that. Immediately address late payments. So give me some good habitability horror stories, because those are always fun, right? And I mean fun like this, not like actual haha fun.
Yeah, so how do I put this? Habitability from a landlord's perspective can be very tricky, because in a lot of circumstances, you might have a tenant who's not paying a lot of money, and then you're not that motivated to put a lot of work into the property, right? They're only paying $800. Am I really going to go and do? I have seen people who've used that kind of logic get hit with very expensive lawsuits, hundreds of thousands of dollars. It's not a good place to be. I will say, in terms of let's say like a survival guide, top priority has to be resolving any orders to comply from the city. If you get an order to comply from the city, you have to make that your top priority to fix, and you kind of have to get into shape, because that will automatically kill any kind of eviction that you want to bring, subject you to all kinds of penalties, liabilities, etc., from the city and from the tenant. So if you have any kind of outstanding order to comply whatsoever, try to address that as quickly as possible. Next, or just to make one more point.
Keep going. I love it. Keep going.
If the tenant messages you about repairs, no matter, let's say, how small, no matter how this, how that, how whatever, address it seriously. Try to, if you can, if you have some regular handyman, send them to inspect, send them to look, and then follow their advice. I get so many people who call me and ask, you know what, there's a joist that's loose on the second floor. What should I do? You should call somebody who knows what to do, right? In this case, some kind of handyman, carpenter, architect, whatever. Somebody is going to have the answer. It's not me. I'm not a doctor. I'm not an architect. I'm not a carpenter. I'm not,
just a premier attorney. That's all you are.
And so you should call, let's say, a specialist, an expert, and then follow their recommendations. So many times, what will happen is landlords will call a specialist. The specialist will say, I think you should do X. The tenant will say, no, that's crazy. I think you should do this and this and this and this and this. And I tell people all the time, follow the expert's recommendation. You don't have to do what the tenant tells you, but you certainly shouldn't, and you shouldn't just decide to do things yourself. Hire someone, follow their advice. That's the safest possible path to resolving issues, is to hire someone who knows and then follow their advice.
That's great advice. And take pictures before and after repairs. That's another good thing to get into the habit of. Like Zach said, if they text you or they reach out to you about an issue, make sure as a landlord that you're documenting this, putting it in the file, saving the invoices from when you have the person go and take a look. Bear in mind that for anything less than $1,000, you don't have to have a license. You can be an unlicensed contractor, but you may want to just go ahead and send a licensed contractor no matter what, even though it's more expensive. And don't forget that you're still in charge of habitability, even if you're in the middle of evicting someone. So I had this happen with a client in Wrightwood. In the middle of winter, they're evicting a renter who stayed on beyond the 60-day notice. The landlord was going to win. It was clearly the tenant had done something wrong in this case, but the water heater goes out in the middle of the winter. And to my client's credit, I said, hey guys, you have to address that immediately. They got it taken care of, cost like $2,500, which was ridiculous, but had to be done, even though they were in the process of evicting the renter. So you agree, Zach?
Yeah. Oh, yeah. I've seen people who get into lots of trouble, particularly less so when they're in active eviction proceedings because they usually are talking with an attorney. But yeah, people who, let's say, they stop getting the rent, so they go and cut the water, cut the power, turn off, yeah, start
Bad idea.
reducing services.
Yeah.
Not a good idea.
Yeah. All right. And then last thing, and then we'll go back to questions. So insurance and asset protection. So very important. And this is one that a lot of, let's say, mom and pop or new landlords forget. They say, oh, hey, I'm going to go buy this property. I'm going to rent out my condo or my house I've been living in. You need to switch your insurance. You do not have the correct insurance as a homeowner that is required when you have a renter. And your insurance company is going to be looking for any reason to not pay on a policy. Any good horror stories there, Zach?
Oh no, we typically don't interact too much with insurance
Yeah,
companies.
I didn't think so, but I'm sure you got something good, something that you just can't share with us. But that's fine. I'm not offended. You've got a lot of good stories. All right, we got some other questions coming in. Had an applicant phone in prior to a vacancy being on the market. She mentioned a service animal, and I groaned. She said, "What?" I told her about a bad experience and was not enthusiastic. Okay, so don't groan over service animals is our advice. I appreciate you sharing this. But service animals are not pets and they're protected under special legislation. You can't charge extra rent, can't charge a pet deposit because it's not a pet. And you can't deny an applicant, even if you have a no pet policy, you can't deny an applicant because they have a service animal. Let's see if there's a question. Okay, there is a question. I made it clear I would rent to her, but did not love the idea of the animal. Did I say too much? What do you think on that, Zach?
Yeah, I mean, you're basically, how do I put this? You're
Insinuating?
you're playing a game you don't want to win. Okay, so don't, I'm not going to tell you you have to be thrilled with it. Okay, and I'm not going to tell you where the line is. I can tell you that if you're on the wrong side of the line, it can be very painful. So do with that what you will. Some people like to go on railroad tracks and wait for a train to come and just jump off before the train comes. And is that is sort of saying is that too much? Well, it's like it's not until it is. So I recommend, yeah, don't. I don't think that what you're describing is too much, but don't go looking for trouble that you don't want to find.
Yeah, I think that's good advice. And look, I get it. It's people do abuse the system. I mean, they're required to have a letter for an emotional support animal, and if they give you that letter, unfortunately, there isn't much you can do. And it can be for emotional support animal, it could be just about anything. Zach loves when we talk about the emotional support alligator. That's one of his favorites, and that was a legitimate thing. It had a letter. Unfortunately, it ended up somebody stole it. But
Hmm.
anyway, that's a whole other story. Hopefully, it wasn't the landlord. You're not allowed to steal animals either.
That would depress me. And then what am I going to do without my emotional support alligator who I rely upon to? He knows all my favorite shows.
Exactly. All right, Cliff. Tenants have proof that the renovation didn't take 30 days, but those renovated units weren't served an eviction for remodel. I feel like we jumped in the middle. I tried to
Yeah,
find the
right.
rest of that.
That's
Yeah.
exactly.
So, I mean, look, to this point, in order to do a substantial remodel, which is now not an option in LA City, by the way, for properties under the Just Cause ordinance, which means basically every rental property. And other than RSO and RSO properties, you do a substantial remodel and they move back in and pay the same rent they did before. Anyway, substantial remodel, the definition in the state law is that it's something that requires the renters to be out for 30 days minimum. That's a substantial remodel, and that's what qualifies for terminating tenancy. So if it doesn't take 30 days, I mean, some things I get it. Like you could go ahead and be served a notice and sit there, move out, and then sit there and see if it takes exactly 30 days. There's always that, and we've had a person who asks a lot of questions on that. But in general, if it's enough work where it's you've got a bunch of permits and it should take about 30 days, because you could also make the argument, well, they're going to just switch out the carpet, but they're going to tell their carpet guy to wait 4 weeks to come with the carpet. And that's not the intent of the law. So anyway, Zach, chime in on this, please.
Yeah, I mean, basically, here's the thing: judges aren't going to know, right? They're not going to supply their own independent judgment about how long a given remodel is going to take.
Yeah.
So you're talking about basically a battle of the experts. So if you bring in a contractor and the contractor says it's going to take 6 months and a crew of 10 men working around the clock to do it, the judge is just probably going to believe that contractor unless you can find the other side can find someone to come in and say, no, it takes 6 minutes. I could do it with me and my friends, in an afternoon or whatever. So, I don't want you to think that, how do I put this? I don't want you to think of this as trying to figure out, like, don't they take 30 days? Figure out who's going to say it is or who's going to say it isn't. And how credible is that person?
Yeah.
Because that's how the judges are going to look and decide things. Because in the kind of the abstract of how long does it take to, how long does it take to replace a sewer main? I don't know. I went to law school, right? I have no idea. Right? Judges going to have no idea too.
Wasn't that on the bar, the exam? You guys didn't have to replace any sewer mains?
You can miss some questions.
No, I appreciate it. That's great advice. Like, bring in the expert in anything you freaking do. Like, if you got a brain tumor, heaven forbid, don't talk to your podiatrist. Like, bring in the right expert. So Cliff did actually tack onto it. So he dropped the unlawful detainer against the tenants. So he wants to serve it again, or will it be harassment? So Cliff was the landlord, and basically he didn't serve the appropriate notice to the renters. So he withdrew it and now wants to do it again. And this is a good question. We've addressed this before. How long should he wait before it's considered harassment of the renters?
Yeah, I don't know that there's a time. To my knowledge, I don't know that there's a time frame that you have to wait. I do think that what I'm looking for with, let's say, LA tenant anti-harassment ordinance is I'm looking for what's the purpose, right? If you're doing it to if there's some reason that people would think that you're trying to do it to harass them, that you're not actually serious about evicting them or proceeding with the case, if there's some reason to think that, then that's problematic. But if you brought a lawsuit, realized, wait a minute, I made a mistake, I need to start it over, that happens, okay? So it's going to be, again, just like the battle of the contractors or experts, this is going to be a battle of two competing hypotheses about the world. So if you, message the tenant saying, I'm going to keep suing you forever, I'm never going to stop, and I don't care if I lose this one or the next one or the next one, I'm just going to keep suing you, and you'll never be done with litigation, and it's going to ruin your life, and your kids will, whatever, starve. And if you're harassing them like that, that's harassment, right? You can see that the litigation, it's not really about the validity or invalidity of this lawsuit. It's sort of just part of an ongoing campaign to hurt somebody else. And these things get said in anger, but I mean, there are people out there who will use litigation as a weapon, to just hurt people, even with no intent to really win. I mean, if they won, they'd be happy, but they're not really trying to win. They're winning by hurting the other side. So if that's what's going on, don't do that. If that's not what's going on, then you're fine. And as everybody, we live in a world that's kind of shades of gray. So what you want to do is make sure that you don't have anything that looks like harassment, and you want it to look like what it should be, which is, I made an honest mistake when I was filling out the first lawsuit. It's my, I'm not familiar with the paperwork. Now I'm doing a second lawsuit, and the reason for the second lawsuit is whatever the reason for the lawsuit is. It's not harassment.
No, and that's great advice. And then Cliff further explains the tenants have proof that the renovations didn't take 30 days, but those renovated units weren't served an eviction for remodel. So there's some important stuff in here. Number one is your renters know the law and are carefully watching. So you're going to want to make sure you understand the law, Cliff, and you can reach out to Zach and the team at California Property Law Group. And number two, those renovated units weren't served an eviction for a remodel. There's other no-fault reasons to terminate a tenancy, and hopefully it worked out. Or you can buy people out. You can do cash for keys. As long as you follow the law in the local area, you can do those things. But Cliff, you've got sensitive renters, so make sure you're following the letter of the law, and definitely reach out to Zach. Free Builder's got another funny one. Funny in a good way. because this is a common one. Had tenants, I've also had tenants refuse to allow access for inspections. How can I insist on inspections? So technically you can't. You can't just say, hey, I'm going to come in and inspect your rental unit. What you can do is you can check to make sure the water heater's strapped. You can check to make sure the smoke detectors are working, carbon monoxide detectors are working. You can show the unit to contractors or prospective purchasers, but just an inspection is not really, and Zach will back me up or tell me I'm a lying turd, but just a regular inspection, you can't do that. But you can do it for those valid reasons, and you'd give the proper written notice to do that. So go ahead, Zach, step in.
You're 100% right. Yeah, that how do I put this? A freestanding inspection is not a valid reason under Civil Code 1954 to enter the dwelling unit unless it's to do one of those things that you mentioned, which is the smoke detectors and the water heater. But I will say that you do. It does help you, and it is beneficial to tell them that you want to come and inspect so that you can make repairs, so that you can find things and fix things. And if they say no, they say you're not legally allowed to come in, right? Then if they ever try and get you for habitability, it's very easy to say, I wanted to come in and you wouldn't let me, because consent is a valid reason for a landlord to enter. And so if a tenant wants to say, I'm not going to consent to my landlord coming in, I'm not going to consent them to fixing anything or inspecting anything or doing anything unless they legally can force me to, it's a lot harder to turn around and for them to turn around and say, and why didn't he fix my water, my water heater? Why didn't he fix the the garbage disposal? Well, because you didn't let him in, right? Because the landlord was trying to do the right thing and you inhibited them. So you're doing yourself a favor by trying to fix things, trying to get ahead of things, trying to be proactive. In some cases, you can do an eviction for failure to allow access. You do need to have a valid reason, and just a freestanding inspection would not be one. But I think that even if they say no, them saying no helps you, right? And I recently had a case where somebody was insistent that the unit was substandard, and the landlord had a number of texts saying, I want to come in and fix things, and the tenant saying, no, I'm not going to let you come in or fix anything. So yeah, right. So make them say no. Make them say no.
And furthermore, there isn't anything in the statute that requires that the renter be there. So especially in an emergency, like if there's a major leak, you don't actually, in an emergency, you don't have to give 24-hour notice, and the renter doesn't have to be there. And so just bear that in mind. But yeah, definitely reach out to Zach and the team to make sure you're doing it right. And you got to have a written notice, proper written notice. All right. So we're running out of, how the heck does this go so quickly, Zach? I always have fun. We didn't even get to try out my fun tech and have somebody call in. Now we have to do it next time. One or two more questions and we're going to wrap this up. So Carla's asking, how do you determine if an animal is really a support animal? People could just print their own letters. Yeah, theoretically they can. California law changed. They're supposed to have a letter from a doctor. There are websites where you can get them, but there's a 30-day waiting period for those websites. So you could try calling the doctor if you're really concerned. What do you say, Zach?
Yeah, I mean, I think that this is, a question that's hot on it's very much front of mind for a lot of landlords and property owners in California, but there aren't really a lot of good options for something like a service animal. I believe you can only ask two questions, which is, what is the animal trained to do? And is that animal trained to perform a particular task, and what task is it trained to do? And that's it. So you're really, you have to understand that the law is really not trying to, how do I put this? You're not really sitting and weighing and balancing. You kind of have to take them at face value. And I mean, that's it. You can make sure that they adhere to the legal minimums, such as they need to be under the care of the doctor for at least 30 days before they can be given one of these. But beyond that, you really don't have a lot of good options that I've ever seen.
Yeah. The emotional support rooster. So that's an actual story. A client of mine, a landlord, had her renter had a rooster, and she had to let the renter keep the rooster until the rooster started to cause a nuisance and wake everybody up, and then she was able to get rid of the rooster. So just bear that in mind, that it's not like it's carte blanche, like you can't not like they can keep it forever. Like a dog can't run around biting people. And there are even highly trained service dogs that will bite people. Irvine Company evicted someone over that. Darn it, I want to keep going, but we can't keep going because Zach's we got to give him a break because he's probably going to have to be, yeah, you got to be in jury trial probably tomorrow. So real fast. So Zach and I and Raphael and Christina, Kenny's not going to be there. He's going to be somewhere else. We are going to be, basically we're going to be doing a trade show together, and it is going to be cool. It is the AOA Landlording and Trade Show Conference. It's going to be on Wednesday, August 20th. We're going to be in Long Beach together, and we're actually going to be up on the main stage. And I think Zach just found that out tonight. I told him before this call. So we'll be on the main stage. We're looking forward to that 9 a.m. It's free for access, just have to pay for parking. So we'd love to see you there. And then we're already at the hour mark. But Zach, why should we hire California Property Law Group as a landlord?
Yeah, we've helped thousands of people. We'd love to help you. We are at the tip of the spear when it comes to this kind of thing, when it comes to evictions in Southern California. I mean, we really have just an incredible wealth of knowledge and experience. And we like meeting people and helping them and seeing people, prevail. So, yeah. If you're interested, you can always give us a call. We're always happy to chat offline and answer questions or get harassed or talk about emotional support animals. Yeah.
Exactly. No, and I will tell you, they pick up the phone, which is unique in the business, and they like to win, which is not unique in the business, but you guys are very good at winning. So I appreciate that. Well, thank you for being here. We'll hopefully do another one of these soon. If not, we'll see you August 20th. Everybody, you and everybody watching, come on by. We'd love to have you there. Thanks for tuning in. Take care, Zach. Be good.